substantive due process. It said that due process includes a right that it read into the Constitution now as a right to purchase and sell one's labor, liberty of contract. Now, in protecting this right, the court said two things. It said, first of all, the state can't interfere at all with this right if the reason why it's doing so is simply the attempt to regulate private contracts. The court said there's no authority in the legislature to interfere with private contracts or to interfere with economic arrangements whatsoever. Second, if the state were interfering with this contract, this liberty, this right to sell one's labor, not for meddling in economic arrangements, but for health and safety reasons, then it could act on that justification, the court said, but the state would have to prove that health and safety was actually advanced by the law. And the court concluded, because it determined it for itself, it didn't defer to the legislature, it said, we don't see, how making healthier bread or anything like that is really implicated by how long a baker chooses to work, so they struck it down. Now, this very activist role for the court in protecting economic rights that were read into the Due Process Clause as economic substantive due process faced an enormous amount of criticism, not just the dissent in the Lochner case, but growing criticism over time, both as to the illegitimacy of the court taking this role, setting itself up to decide, as against the legislature, what economic and social objectives were permissible, and setting itself up to decide what laws in this area were reasonable. The question for many is, where do you get this right of contract? And in any event, why should the court be in a superior position to say what kinds of regulations of the economy are good or not? Many regarded this as illegitimate, anti-democratic, quite inappropriate. And it was especially problematic as we worked our way into the Depression for the court to set itself up in opposition to social and economic legislation of the day, particularly as it was designed to bring us out of that depression. In any event, the wheel turned. In the 1930s, we had a change, both in the people who were on the court and also in the view of the court's proper role under due process of law. The court's changing sense of what's legitimate and what its own competence required led it, in effect, to reject its own past precedents and to turn away from economic substantive due process. In fact, to turn away so dramatically and so completely that now, today, substantive due process for economic rights is essentially a dead letter. And it's a dead letter for the following reason, or reasons. First of all, the later courts rejected the idea that there is any fundamental constitutional right in this economic sphere, right of contract, and it rejected any role for the court to second-guess legislative judgments in the area of social or economic legislation, where the legislature is regulating marketplace interests or social interests, where it's regulating prices or wages, the registration of motor vehicles, business practices, anything like that, anything in that sphere. Later courts said legislatures are best able to judge and have the authority to judge what's needed, what's wise. So today, in terms of legislation that affects economic or social interests, we have a very, very lenient test that the court applies under due process, and it's called the rational basis test. Under this test, quite to the contrary of Lochner, under this test, there is no fundamental right of freedom of contract. There's only a protection against arbitrariness. Under the rational basis test, laws are presumed constitutional. And if there's any rational basis, that is, any facts whatsoever that support the adoption of laws, so long as it's not arbitrary, the law will be upheld. In fact, the court will search the universe for any reason that it can think of that will make a legislative judgment rational and will uphold it. Any legitimate government objectives will be upheld. In effect, the court has basically left this field to the point where it's pretty clear that under substantive due process for economic rights, rare is the case that a plaintiff will win. terms of someone challenging an economic or social piece of legislation as violative of substantive due process, the rational basis test is so weak, it's such a little midget of a standard, that to invoke this test is basically to announce that the government wins. However, I do want to note two areas where economic and property rights have gotten a bit more protection recently. So although I want to continue with the discussion about substantive due process and show you how fundamental rights, although it's turned away from economic substantive due process, has found new expression, new vigor in the area of fundamental personal rights like abortion and contraception. Before I do that, although I leave you with this general understanding that social and economic rights are only weakly protected under the Due Process Clause. They're only protected against arbitrariness. Lochner versus New York is dead letter. Nevertheless, in two areas, the court has begun to ratchet up a little bit more protection. One is the protection of property rights under the Takings Clause, and the other is the limitation the court has begun to impose on punitive damages under the Due Process Clause. So first, I'm going to give you a thumbnail sketch of the Takings Clause and then mention something about these punitive damages limitations. So, thumbnail sketch under the Takings Clause. In the Fifth Amendment of the Constitution, the government is prohibited from taking property without just compensation. Now, this is the exercise of eminent domain. Governments are allowed to take property, but if they take property, they have to provide just compensation. They have to take the property for a public purpose, but that's fairly easily satisfied. And if they want to take it, you can't stop them from taking it. You can't get an injunction, but they have to pay you for it. And the theory of the Takings Clause is, if the government needs property for a public purpose, it's not fair that the one person who happens to own that property bears the full cost. Instead, the full public ought to pay you for it because it's for the whole public's benefit. Now, we can't get into takings jurisprudence at any length, but there is an aspect of this that I want to mention, and that is what amounts to a taking. Because even though you can't stop the government from taking it, if it is a taking, you can have the government pay compensation. And the takings protection is applied to the states through the Due Process Clause, as well as other protections of the Bill of Rights, so it applies against state and local governments too. Well, the rule in general is that any physical occupation of property or appropriation of property, even if teeny tiny, counts as a taking. For example, if the government authorizes, the cable guy to run wires across your property, even though it's just a teeny tiny intrusion in that sense, it's a physical occupation, and they have to pay you for it. So any physical occupation or appropriation of property certainly counts. But the real issue in the takings area that relates to government regulation of economic and property interests has to do with the question, when is regulation of property so extensive that it also will amount to a taking? Now, until fairly recently, what the court has done with regulations, for example, zoning laws or other kinds of laws that affect how you can use your property, it's applied a balancing test. It's looked at the degree of intrusion of the regulation, the diminution of value, versus the benefits of the regulation to the society. However, even though I'm saying it's a balance, and even though there were some cases found to be takings, even though they were simply regulation and not actual physical appropriation of property, pretty much the rule was applied in great deference to the government. The burden was on the challenger to make out an extreme case, and it was fairly well understood that rather extensive regulation would be permissible to the government, and we understand that we need that in a modern society. You just can't do what you will with your property. There are very important public issues involved in how you use property. However, there were three fairly recent cases by the Supreme Court that signaled